Amendment to H.R. 2666, offered by Mr. Walden.
I offer this amendment to address the concerns expressed during the subcommittee consideration of H.R. 2666. Now, in that markup session, our colleague, Ms. Matsui, offered an amendment that proposed a number of exceptions to the no-rate regulation rule. Among them were concerns the bill would prevent the FCC from using the Universal Service Fund rules to ensure comparable rates between urban and rural areas, concerns that this would concerns that this would authorize paid prioritization, and concerns that the FCC would be hampered in enforcing its truth in billing rules. I listened to Ms. Matsui. I thought her comments made a lot of sense, and this amendment clearly addresses those particular items that Congresswoman Matsui raised during the subcommittee markup. I appreciate her always constructive role on this important subcommittee. Now, unfortunately, we could not reach agreement on some other elements of her amendment. The amendment offered at subcommittee asked us to give the Federal Communications Commission authority to act to regulate discriminatory practices and, quote, to act in the public interest to protect consumers or regulate the billing practices employed by or penalties or fees charged by providers of broadband internet access service. Now, while these statements all sound good on the face, in the hands of the Federal Communications Commission, they would actually reverse. The practical effect is they would reverse the no-rate regulation purpose, which is the purpose of this measure. If we were to accept these provisions, in fact, we would tell the Federal Communications Commission, don't rate regulate unless you think it's a good idea to rate regulate. So that would be inconsistent with the underlying purpose of the bill, inconsistent, by the way, with the President of the United States' own statement, and inconsistent with Chairman Wheeler's repeated statements to us and to the public. Post facto rate regulation is a dangerous regulatory weapon that will threaten competition and innovation in the rapidly evolving internet marketplace and thereby reduce consumer choices. What we were able to achieve is an amendment that addresses the concerns that we share. The language in my amendment, Mr. Chairman, ensures the FCC can continue its ban on paid prioritization, can continue to ensure comparable rates between urban and rural customers, and can continue to enforce its truth in billing rules. Those are all protected by this amendment. I believe these are important consumer protections. I believe we all can embrace them. Throughout the drafting of this bill and our amendment negotiations, our guiding principle has been to codify the bipartisan agreement expressed by President Obama, Chairman Wheeler, members of this committee, and the Senate Committee on Commerce, Science, and Transportation. The changes proposed in this amendment improve the bill and further that goal. And I urge my colleagues to support this amendment and the underlying bill.
Mr. Chairman, I can't support the amendment offered by Mr. Walden. We have an unfortunate pattern developing in our committee, and I think it's important to note it now. Republicans claim they're willing to consider our concerns, but it has become apparent that such consideration is dependent on the Republicans doing it for us. This amendment doesn't effectively address Ms. Matsui's concerns. On this bill in particular, almost every time the Democrats have dared to provide specific written concerns ourselves, the response from our colleagues across the aisle has been a resounding no. To be clear, we had no hand in the drafting of this amendment to supposedly address our issues, and in my opinion, this amendment is just another example of the folly of this partisan approach that we're seeing today.
My concern about both these bills today, and I agree with you that some of these things we could deal with, particularly on this bill, but there's no cross the aisle working together on it, and that's unlike what we did last year with a lot of our bills last year in the odd-numbered year that we had. We worked on cures, worked on a lot of different bills that had bipartisan support, and particularly on this bill, I think we could probably get to bipartisan support. I have to admit, on the health care bill, we couldn't get there with what the cuts are. But I hope our committee's not going to consider doing this for the rest of this year, because it'll make it a really difficult session for us, simply because if you come out with only Republican votes, it may pass the House floor, but it'll never get past the Senate. And if you want to actually legislate, we need to have folks talking across the aisle.
I just want to call this for what it is. First of all, let's talk about a bill that passed out of this committee after bipartisan negotiations, very productive ones, the small business exception bill for the FCC on the reporting requirements on internet. We met, we had disagreement at sub, we worked with the Democrats, and guess what? We came out unanimously. Unanimously out of this committee, probably passed unanimously on the floor. The FCC process reform bill, bipartisan bill, we worked out our differences, came out of this committee. The .com Act, bipartisan bill. Our staffs actually worked quite closely together on that one as well. The consolidated reporting bill, FCC process reform and consolidated reports.
Let me take back the time. I'm not
bipartisanship.
suggesting, Mr. Walden, that we didn't work together on those other bills. I appreciate the fact that we worked together. The point I'm trying to make is that we did not work effectively on this bill. I don't want to give the impression that your amendment addresses the concerns that we have that were in Ms. Matsui's amendment. I think you made it quite clear in your statement earlier that it doesn't. Maybe it addresses, a few things, but it doesn't address most of it. And I think Mr. Green's point is quite apt. He's basically saying that if we want to actually get a bill that's going to pass the House, pass the Senate, be signed by the President, we need to do a lot more work on a bipartisan basis. I'm not arguing about what we've done in the past on the other bills. I agree with you, but I think that it's quite clear that we're not making progress on this one and that we shouldn't have had the markup today because it's not going anywhere. That's my only point, and that's why we're going to be offering the amendments from Ms. Matsui as well as Ms. Eshoo, because we're not there, and I just don't want to give the impression to our Democratic colleagues that we are. We're certainly not. If you want to add anything else.
Well, I appreciate the gentleman's clarification because I was trying to, in my own statement, be very clear that we were able to reach agreement on at least 3 of Ms. Matsui's concerns. The others, I said very clearly, we couldn't find common ground on. That's kind of the legislative process. So
I
appreciate your
understand.
admitting
I don't disagree with you. Let me take my time back. I don't disagree with you. I'm simply saying that I think Mr. Green is right. We can work further and come up with a consensus bill on the points that Ms. Matsui and Ms. Eshoo raises, and I just hope that we do. We're certainly not there yet.
I just want to say thanks to Chairman Walden for offering this amendment today. I've said many times before, the intent of this legislation is simply to ensure that the government's not in the business of mandating what rates consumers are going to pay for broadband. Very simple. Time and again through this process, we've heard the argument that the language in this bill, as it stands, might have unintended impacts in other areas of regulation. For example, when Harold Feld was before the committee, he specifically mentioned billing practices and the Universal Service Fund. We took those concerns to heart. Additionally, during our subcommittee process, some more areas of concern were mentioned. Just to ensure clarity of argument, I'm going to read a small outtake outlining the arguments from the transcripts of that subcommittee markup. It was stated, quote, "The bill is far broader and could eviscerate the FCC's authority to protect consumers against truth in billing practices, discriminatory data caps, to ensure that broadband availability through the USF and E-rate are protected to address rate-related issues, and merger reviews to ensure enforcement against paid prioritization." Those are all legitimate concerns. So let's take a look at what's in this amendment. Number 1, nothing in this act shall impact the authority of the Commission in regards to the Universal Service Fund. Cool. Nothing in this act shall impact the authority of the Commission in regards to truth in billing. Awesome. Nothing in this act shall impact the authority of the Commission in regards to paid prioritization. Straightforward. For the purpose of this act, broadband internet access service shall not be construed to include data roaming. Excellent. For the purpose of this act, broadband internet access service shall not be construed to include data roaming interconnection. So as you can see, this amendment not only clarifies that the bill before us would not touch those areas of concern, but we actually go even further to ensure that the intent of this legislation moving forward. We really want this legislation to be bipartisan. And I appreciate working, our staff and leadership and everything, working with the other side of the aisle. It's been great. But in a negotiation, neither side necessarily gets everything they want. We had 5 areas of concern that were offered. We have 3 of them in there. I mean, this is a strong move to bipartisanship. But the idea that bipartisanship becomes totally capitulate to my side, which is what I'm hearing is just unrealistic. So I want this to be bipartisan. I hope it is, but you know, we'll see. I think it's important to note too, lastly, Ms. Matsui, and I appreciate having worked with her, but the universal service with her concern, truth in billing, interconnection, those are all in here. So it may not be everything, but it's a really good step to bipartisanship.
I'd like to ask some, we didn't see this amendment until maybe 2 hours ago. It was introduced, or we saw it this morning. So I'd like to ask some questions of the council relative to the definition of rate regulation. Can you briefly describe the way that, that this amendment actually defines rate regulation?
This amendment defines the term rate as the amount charged by a provider of broadband internet access service for the delivery of broadband internet traffic. The bill also defines broadband internet access service as the meaning given such term in the rules adopted by the FCC as part of the Open Internet Order. The term regulation is defined as regulation or regulate means with respect to a rule, the use by the Commission of rulemaking or enforcement authority to establish, declare, or review the reasonableness of such rates.
And where did this definition come from? Is it a definition that is used elsewhere in the law?
The definition of broadband internet access service is used elsewhere in the law. The definitions of rate and regulation are for the purposes of this act.
So it essentially rests on the definition of broadband and what you just described, not anything else.
All three of these definitions work in conjunction to define the scope of the bill.
Just on broadband. Now, are you aware of the definition of rate setting the Supreme Court recently adopted? The Federal Energy Regulation Commission versus Electric Power Supply Association?
I don't have that in front of me now.
All right. Well, I think that I think it's important to draw from, and I don't think it has happened, where you choose not to use tested Supreme Court definitions rather than writing your own definition without any legal vetting. I mean, we are writing a law. This is a markup. This is not just it's an important debate, but we're writing a bill. So these are very important tenets, I think, that need to be honored. Now, in the description from our friends in the majority, and I want to thank you for where you have moved to. You have moved. You've moved somewhat. You've moved somewhat. But data caps are not in this. Merger reviews are not in this. FCC transparency are not in this. And general conduct standards of the net neutrality rule are not in it. Now, maybe you think these things are a pile of junk. I don't know. But they are, they are very important elements. So I agree with our ranking member.
Would the gentlelady yield on that?
Just a moment. I just want to finish, and then I'd be glad to. I don't think that this effort is ready for prime time. I really don't. And I want to make something very clear, and that is that the Democrats are not for rate regulation of the Internet. We are not. And that's why I offered before, I will offer again, the amendment that codifies exactly what the majority has been saying all along. Where we somehow have hit the ropes is that we're starting to get into, well, we'll allow the FCC to do this, but we won't allow the FCC to do that. And I think that that's skating on thin ice. I really do. I don't know where the FCC has gone so wrong on data caps, on merger reviews, on transparency, on the general standards. So I think this needs some more work. And I hope with more work that we can come to an agreement. So with that, I'd be glad to...
Would the gentlelady yield?
I'd be glad to yield the remainder of my time to the chairman of the subcommittee.
I appreciate that, the gentlelady, and I appreciate her comments. nearly everything that you raised of your concerns that's not in here, they're not in there because the authorities continue to exist under the Federal Communications Act, under the Open Internet Rule, to continue to regulate. We didn't address any of those. So, because I know you
But
support
let me
the
ask
open.
you something. I'm not a lawyer, but
That's two
are you?
No,
No, good.
that
Okay.
usually gets a round of
So
applause.
it comes from the same starting point. When under the your amendment's definition of rate regulation, does that include what I mentioned, even though you don't mention it in your amendment?
Could you read me the list again? So we get
Data
this right?
caps, merger review, FCC transparency, general conduct standards, you know, the net neutrality rule. Are those all just assumed and covered under your new definition that the council just read?
So mergers, I'm told, has been outside the bounds for 25 years, and so we don't address that. What were the other ones? I'm sorry, we can kind of go one by one.
Data caps, merger review, FCC transparency, general conduct rules.
They would not be allowed to regulate data caps under our bill. That's true. Transparency rule stays the same.
Well, see,
We don't address that. But so
we're over our time. I don't know if anyone wants to yield.
Could we ask
I was
Ms.
letting you be.
Pastor-
I was letting you be constructive. So
Keep going.
Thank you, Mr.
till it
Chairman.
digresses.
See, I think that this is where the problem is. First of all, the amendment was filed a couple of hours ago. So we're asking questions to find out what's in it, what does it bump into, what does it protect, what does it leave out? And I don't know if anyone on this side is really fully cognizant. I can't answer those questions.
I think
And
we can address them.
I think that you just
Yeah.
attempted to, but that's why I think this needs
Yeah.
more work.
Well-
I sincerely mean that, and I think that you
And-
and I need to sit down and talk, Mr. Chairman, and
Happy
not just
to.
our staffs.
Anytime. So I think we can address each of those issues and have with our legal counsels. Second, our amendment was filed approximately the same time. All amendments are filed well within the rules, 2 hours.
Well, I was criticized for filing something 36 hours ahead of time. Now we have a new standard, so, you know, it came in under the wire. The point is not
that was
the
a much
hour,
different-
but the knowledge. You
Happy
see?
to give it to you.
Yeah. So that's why I'm asking the questions, and I would just ask you
we-
directly if you can postpone this, and that we take another stab at this to see if we can come to a meeting of the mind, of our minds. You know, I think it deserves that. If not, then we'll proceed. But that's what I would ask in all sincerity, and see if we can reach an agreement.
Well, I'm always open to sitting down and talking. As you know, I'm always open. Our side is to negotiating these things. When issues have come up, like Ms. Matsui raised 4 or 5 issues, we had that discussion, didn't agree to everything that she had concerns about, but this is a legislative process. 3 of them are, I think, addressed appropriately here. On some of these issues, we just have a disagreement. This bill was filed a year ago. We've had the due process of hearing on it in subcommittee, markup on it in subcommittee. Now we're here to mark up on full
Well, I
committee.
think reclaiming
and
my
so
time. I think it's my
well, I don't know
time,
who's
isn't
got
it?
the
Yeah,
time.
reclaiming my time.
Time
Is
is
it?
now expiring.
Expired.
However,
Okay.
let me just say that I would encourage both of you to perhaps, as you suggested, sit down together. It's going to be a while before this bill gets to the House floor. If you're able to reach a further accommodation on an amendment that addresses the concerns that not only Ms. Matsui raised earlier, but now, I certainly would be willing to help urge the Rules Committee to allow such an amendment.
Thank you, Mr. Chairman. I'd like to strike the last word and oppose this amendment on the underlying bill. As has been discussed, that this amendment was filed this morning, so we've had very short time to read the text or discuss the full ramifications of the language with the FCC or any other expert authority. But in the short time that we have had to look this over, I can tell you that I have grave concerns about it and the underlying bill as well. You know, at the subcommittee markup, there seems to be some misunderstanding between our two sides about what opposition to rate regulation means. To be clear, What I mean is that I do not support ex-ante regulation, which is what the FCC explicitly prohibited in the Open Internet Order. I, along with many of my colleagues, agree with Chairman Wheeler and the majority of the FCC that they should not be in the business of explicitly setting the cost of broadband service, nor should they be in the business of explicitly approving or denying rate changes. What I and many of my colleagues on this side of the aisle do not agree with is this legislation and this amendment's attack on the FCC's ability to enforce the Communications Act and its own rules. While I appreciate that this amendment carves out universal service, truth in billing, and paid prioritization, I believe that it puts at great risk the Commission's enforcement authority, its ability to evaluate mergers, and its ability to act in the public interest. One of the most notable carve-outs, not in this amendment or the underlying text, is the one for the Open Internet Order. This omission would seriously endanger the FCC's ability to evaluate zero rating programs, enact or enforce any forthcoming rules to protect consumer privacy, or enforce the Commission's general conduct standard. These rules are intended to protect consumers and the vibrancy of our innovative and competitive online economy, so it's unacceptable that this amendment and the underlying bill would undermine them. This amendment does not address the underlying harms this bill will do to the Internet ecosystem or the American people. Therefore, I cannot support this amendment, and I encourage my colleagues to do the same.
I would ask the gentleman, do you support things like the Binge On initiative from T-Mobile?
We have some concerns about that.
You have concerns about it, okay. The reason I raise that is, by all estimates, some 34 petabytes of data have gone through that program so far, saving consumers maybe as much, maybe, these are just rough estimates, $100 million. Consumers are actually getting a choice here on Binge On, and I'm not advocating T-Mobile or anybody else, but I'm saying this is the kind of innovation in the marketplace that consumers are going to, and it's saving them money, that the FCC has said, well, maybe this is okay, but you know what, we're going to take a look at it too. And we may come back and say it wasn't okay. But and so I'm trying to get to where the
But Greg, there's a lot of providers that aren't in this. YouTube's not in it. Facebook's not in it. I mean,
by choice.
I think what this boils down to really is whether or not you believe the FCC should have the ability to enforce
if the gentleman yield, Facebook, I believe, is doing a free data process overseas and here too. I mean, the companies are innovating. That's why I don't understand the objection to stopping the FCC from post facto rate regulating by coming back on them or T-Mobile or somebody and saying, you know what, it wasn't really fair, so now we're going to come back and punish you. That is what suffocates innovation in a vibrant marketplace that heretofore has not labored under the heavy hand of government regulators.
Listen, this is to make sure that ISPs aren't picking winners and losers. Okay, that's what this is about. I just think, and the bottom line is this, is either you believe or you don't believe that the FCC should have the ability to enforce its own rules, act in the public interest, approve or deny mergers. That's not just rate regulation. That's the Commission doing its job. And if you disagree with that, that's fine, but we don't.
I just wanted to add something to this. To Mr. Walden to consider. If the provisions that are left out of the bill won't be impacted by the bill, why not just say so explicitly? I just put that out there because I think it's an important thought if, in fact, we get to sit down and talk about this and put this off to another day and see if we can come to some kind of an agreement. We may have too much of a chasm, but I think we should try.
My questions follow up on Ms. Eshoo's question about the definition of rate specifically. Can you tell me where the definition that is included in the amendment comes from?
This is a definition that was drafted for the purposes of this amendment.
So this definition was drafted for the purposes of this amendment. Were there reference materials that were used for the drafting of the definition of rate in the amendment?
Yes, in the process we looked at different definitions used in different contexts, including different court cases.
Can you tell me which court cases you used?
I don't have the citation with me, but one of the cases was the Supreme Court's decision in Hope.
It was really elected official that helped write this definition, that'd be me, with the support of council, obviously, because that's what we do here is we write law, we define things, and that's what we're doing here. And we did look at the FPC v. Hope natural gas case, which, as you know, having been a regulator, sort of set the standards for what rate regulation and tariffing is. It's a 1944 case from the Supreme Court.
As we look at the case from 1944, there's been a lot that's been derived from how rates have been treated. Having the honor of serving on a regulatory body in the mid-2000s, sitting before different rate proceedings, we've been in front of that. Ms. Eshoo asked specifically as well if the council was familiar with the more recent rendering by the Supreme Court with the Federal Energy Regulatory Commission versus Electric Power Supply Association. Are you familiar with that case?
I'm not, I do not have the case in front of me, so I'm not.
Was that case used in any way to look at the definition of rate, since it's more updated from 1944?
No, because this is an issue of first impression.
Appreciate that. Not being an attorney, I appreciate that.
And just one other note, by the way, the Communications Act is from 1934. So it's actually 10 years older than this court case, but this court case fundamentally set the rate of how you determine a rate of return and all of that, as you know, in the R equals 0 plus V minus DR.
My question to council again is, last time I asked if you all used a dictionary. This is an old version, maybe published in 1944, of a dictionary. Today you can go online, and Webster's has a simple search engine derived by Yahoo or Google or just about anyone else. You can get to Webster's. There's various aspects of the term rate that's defined inherently therein as well. All that I'm saying here is, with the complexity associated with how this term is going, and did council use the definition of the dictionary?
We considered various definitions of the word rate and drafted a provision that we think best reflects the intent and purpose of this
Okay.
bill.
And real quick, Mr. Chairman, if I could just ask one other question, because this gets to the specificity associated with the definition that's used. And I appreciate that there was an attempt made as well to define this. I think we need to get closer to defining rate as well. But my concern is this: as we look at rates, inherently with all aspects associated with charges, can council guarantee me that paid prioritization is not impacted by this definition of rate?
This amendment explicitly has an exception that says nothing in this act shall be construed to affect the authority of the commission to enforce section 8.9 of Title 47 Code of Federal Regulations, which is the codification of the FCC's paid prioritization rule from the Open Internet Order.
But then the definition of rate goes on to say anything charged for internet services. So anything charged for a service is inherently all the costs and all the inputs into what's going to be charged. So if there's an aspect here with how vague we are with these definitions, that's our concern here. Ms. Eshoo offered an amendment during the subcommittee markup that would have codified the FCC's order that we all say we agree with. It would have put that into this definition. It would have put it into law. It would have made clear that, as Ms. Eshoo made very clear, that Democrats do not want there to be rate regulation, tariff regulation, charge regulation, whatever it may be, with the setting of paying for internet services by the FCC. Let's be clear about that. But Ms. Eshoo's amendment would have done that.
Let me respond to a couple of points. First of all, let me set on the record that the Republicans did not fully embrace in its entirety the open internet order from the FCC. So that's a bit of an overstatement from that. What we do oppose is blocking and throttling and paid prioritization and the offensive things. We did not support the Title II common carrier regulation, take the internet backwards into when we regulated canals and railroads and telecommunications, electric grid. So let me clarify that for the record. I know he didn't mean to overstate and drag us into something we're not a part of. Second, this is what we do is define things. We do it all the time here in Congress, and what we're doing here is defining a rate means the amount charged by a provider of broadband internet access service for the delivery of broadband internet traffic. We did look at other legal sites. We did look at other legal precedents in coming up with this definition. And so, I mean, it is what we do here. And so I think it's reasonable. What we don't want, and I would hope that you would agree with me on this, what we don't want is a commission, either this one or a future one, that has post facto penalty rate regulation, where you have innovation in the marketplace like I cite with Binge and other companies, and then an FCC, including this one, that is saying, well, we're going to take a look at that. It's out in the market. It saved consumers maybe $100 million. I don't know the number for sure. That's a big ballpark estimate on our part. But given the amount of data and kind of the data rates, we did an estimate. But the long and short of it is consumers are making the choice, not the regulator. But the regulator could come back and say, well, gee, you didn't ask Mama, may I? But then you didn't really have to. But we can come back afterwards and said, hey, you went afoul. And that's the thing we're trying to stop here and define it. And maybe this FCC won't go down that path, but there's no guarantee the next one won't. And so I'm not a fan of a big, heavy FCC regulatory arm, 3 people, really 1 chairman, whoever that is in the future or today, that can come in and decide the whole fate of the internet and snuff out innovation and the kind of technology we've seen. Because remember, we've gotten here without Title II regulation. We've gotten the innovation, the jobs, the technology, the consumer choice without Mother May I, or gosh, did I make a mistake, or I thought it was okay, and then they come back and whack you. And that's what we're trying to avoid. You want to join with us? I've had draft legislation for more than a year open to the Democrats to join us to simply block paid prioritization, blocking, throttling, the things where we do find common ground. I'd welcome you to be a part of that. We can't go as Republicans all the way to Title II regulation and government intrusion in the internet. We will be with you on stopping the bad behavior and punishing it, no question, clear. But now you're going to have a court case that may well decide it's okay to regulate on the hardwire side, but not on the mobile side. That may well be the outcome. And then what kind of internet are you going to have in terms of regulatory environment when we're all going mobile? And so I wish we could find common ground on this other point, but so far no takers. So
I've tried not to get too involved in this debate, but at some point in time you just have to kind of tell the facts are the facts. This is a 1-sentence bill. 1 sentence. All you got to do is read the bill. It says you're not going to regulate the rates charged for broadband internet. Why do we have to have the bill? Because the Obama FCC has bent over backwards to try to figure out a way to get regulation of the internet. And they did it through this order. And so the chairman of the subcommittee, with the support of the full committee chairman, has introduced a 1-sentence bill that a 4th grader can understand. And I was here in 1996 when we passed the Telecommunications Act that created what today is called the open internet. And we consciously made a decision that we weren't going to have any kind of rate regulation, and that has worked until this FCC has taken it upon itself to try to shoehorn regulation into Title II, the 1934 Communications Act, when we had a monopoly in this country of hardline telephone service. This is a simple bill. We should all vote for it. And then in the next administration, if we need to go back and clean it up, let's do it. But I strongly support the bill. I strongly support the amendment because it is an attempt by the subcommittee chairman to adhere to some of the issues that the minority raised in subcommittee and in earlier amendments apparently this morning at this markup. It's that simple.
My Republican colleagues have offered this amendment, and it would preserve the FCC's authority over some policy issues with regard to consumer protections. This amendment only singles out subpart Y of Part 64 of Title 47 of the Code of Federal Regulations. I'm concerned with the FCC's critical consumer protections that they've been omitted from this amendment. Counsel, could you tell us whether the Communications Act or FCC rules specify any other consumer protections?
Could you clarify the question, please?
Yes. According to this amendment, we're looking at singling out subpart Y of Part 64 of Title 47 of the Code of Federal Regulations. And the FCC has a critical role in consumer protection. So I was wondering if you could tell us whether the Communications Act or the FCC rules specify any other consumer protections.
The Communications Act does contain other provisions that are related to consumer protection. This bill only addresses the regulation of rates as defined by the bill.
But do you know whether it includes the truth in billing provisions of subpart Y of Part 64 of the FCC rules?
This bill this amendment explicitly carves out those rules, the truth in billing rules codified at subpart Y of Section 64 of the 47 CFR.
Well, given the way that this amendment codifies the FCC truth in billing rules, would the commission be able to amend these rules in the future, or would these rules be frozen in time by statute?
This would codify, or this would accept anything codified at that portion of the CFR.
So frozen in time?
No, as long as they are codified in that subpart Y of Part 64 of Title 47 related to.
I think as long as they could continue to amend under their existing authorities on truth in billing and all, as long as they don't get into rate regulation, which I think we have general agreement we don't want them to do. So they could still, they've got general authorities they can use. We just said here we're not touching what they've already done in terms of, we want them to continue to have that authority. We just don't want it to spill over into where they do post facto rate regulation, if you will.
The last time I checked, it's only Congress that can write a statute. Is that, counsel, is that right or is it wrong?
That is.
I mean, is it right or is it wrong?
That is accurate.
All right. So this business of going left and turning right and going north and then go southeast and southwest and you can and you can't and we're going to pick and we're going to choose. You know what? We're skating on very thin ice in a markup to consider something that is applies to some things. We're not so sure about other things based on laws that are old and what is present has really not been taken into consideration and vetted. So this is really getting messy. And to Mr. Barton, who is my cherished friend and partner on this committee, I don't care if it's one sentence or one page or 100 pages. It says what it says and it falls short. It's not as simple as, I wish it were simpler. I tried to make it simple.
And I'd like to note that the critical consumer protections embodied by the FCC's transparency rules are not included. Isn't the purpose of those rules to protect consumers and make sure they have sufficient information when purchasing broadband internet services? Madam Counsel?
I don't believe that those rules are affected or impacted by the amendment before us.
You don't believe that?
Because they are not related to the regulation of the rates charged, which is what's addressed in this amendment.
But when they purchase their broadband internet services, the rates are baked in, aren't they?
The transparency provisions are separate from this amendment. They are not affected by the way that the language.
And I think that really proves the point that my colleague, Ms. Eshoo, and so many others have stated. If we're going to be legislating, creating statute in the 21st century, I think that we need to take the time to do the work that's required so that we're dealing with a comprehensive matter, this matter in a comprehensive manner.
I just have to clarify this. We believe in all the consumer protections my colleague from New York just talked about. That's why specifically in the legislation, we say, you still have all that authority over there on consumer billing, all those things. This is what's bizarre here. I'm having trouble following because we specifically in the legislation to address the issue that the gentlelady raised from New York say, none of this applies. FCC, you still have your truth in billing. You still have all the consumer protection you've always had. This doesn't address, this just says on rate making only. And by the way, if we want to talk about ages of statutes, the FCC is going back to the 1800s when they regulated railroads and all to regulate the internet. I mean, it was, and you've got a 1934 Communications Act. So the age isn't the issue here. It's trying to make sure that consumers have all the protections. We do that in this bill. We don't mess with that. A simple reading of it will say that's why we do exceptions. and we put it in here to make it doubly certain, we wouldn't even have to have this in here to leave the same authority the FCC has. We specifically said, though, nothing in there takes away that authority. Second, what we are concerned about is a runaway FCC that will engage in rate regulation in reverse. They'll wait until a company has proposed something and has it out in the marketplace, and then they'll come back and second guess what was offered to consumers. That's why I point out what T-Mobile is doing. T-Mobile has a product, they put it out to consumers. Guess what? There's been big uptake by consumers, apparently. I mean, we saw, what, 34 petabytes of data, maybe $100 million in savings to consumers. That seems like a good thing. It's pro-consumer. This is a pro-consumer bill. This is a bill that says let's continue the vibrant marketplace we've had under the internet economy to allow people to innovate and not have a regulator for the first time come back and be able to say, sorry, you got it wrong. Here's the penalty. Stop what you're doing. These plans that are out there just starting to emerge in America are being used by others in other countries today. This is, the consumers will react. They'll react a lot faster than an FCC or a Congress. We're just saying, here's what rate means. It means the amount charged by a provider of broadband internet access service for the delivery of broadband internet traffic. And, you know, regulate, it's pretty simple. The term regulation or regulate means with respect to a rate, the use by the Commission of Rulemaking and Enforcement Authority to establish, declare, or review the reasonableness of such rate. We define all this. It's a pretty simple bill, but it has big impact for consumers in a positive way and for innovation technology.
I couldn't disagree more. I'm very concerned that this bill is going to undermine the FCC's ability to protect consumers. And going back to what Mr. Barton said before, you know, he says this is a very simple bill, but it's deceptively simple because it says only that the FCC may not regulate rates, but as many experts have pointed out, and I think the debate here shows that the term rate regulation could mean anything. And, you know, the Republicans claim that they intend the bill to be narrow. We've heard over and over again, though, that from our side, that this could swallow vast sections of the Communications Act.
We've been very careful to make sure that consumers are not only protected, but they continue to have a vibrant marketplace where providers can innovate and offer them new choices. That's what's grown the internet to begin with. That's what we embrace. It is this FCC, who, by the way, initially did not want to go down the full Title II regulatory common carrier path until they were forced to by the White House. You know, that's what we're trying to avoid here is full rate regulation or post facto rate regulation, the worst form of regulation, and that's what you're going to get. That's what you're going to get from this FCC or the next one is second guessing on rates. They're going to get involved in this, and you're going to regret the day that we did not pass this if we don't get it through here. So, Mr. Chairman, I yield back. I think we've made our case. The only final point I would make before yielding is for my colleagues on the other side of the aisle, I would think you would actually want to support this amendment since it improves the bill and addresses at least 3 of the issues Ms. Matsui raised, and then whatever you want to do on the final passage.
The vote occurs on the Walden amendment.
Mr. Chairman, on that vote, there were 28 ayes, 21 noes.
28 ayes, 21 noes. The amendment is agreed to.